Hey everyone, how are you? Can you hear me? Give me a thumbs up if you can hear me. Great. Screen is good. I'm doing the second sound check and visual check. All right, good. Team. Right, are good to go. I think everybody joined, right? Got most people here. All right, perfect. So, let's see who we have. We have Franciele, we have Christina, we got Jeffrey, Vanessa, we have Nurka, Yvette, Miguel, Ingrid, Stephanie M. We have Elena, Jacqueline, we have Fabiola, we have Chris, Erica, Muslima, Bianca, David, Verona, Stephanie. We have Teresa just joined us, Millie, Pedro, and Mina. All right, cool. You guys have any questions regarding the previous chapter? I know some of you already came here to get the book. I know some of you are asking about the book. Whoever purchased the book, it was already mailed out. All right, it was mailed out today. So Chris, I know you sent me a message earlier. It was mailed out. Nurka, you also sent me a message because you purchased today. So we ordered more books because the books that we had ordered was already a little bit more than what the class wanted. So we got a little bit more books, but we weren't expecting to have a lot more people asking for it. So we ordered more. They should be here by, it's either by Monday or Tuesday, I think they get here. All right. So they have a timeline till Wednesday. That's what it says there. But this one was also until Friday, and they got here yesterday. So we're hoping Monday or Tuesday, okay? Miguel wrote TE. What's T? All right. So if anybody's interested in the book, I did share the link in the WhatsApp group. I shared last night. I'm going to put here as well. If anybody wants. All right, question from Miguel. And I just put the link, guys, if you saw it. If anybody's interested in the book, we did order a few more books. If anybody's interested, this is where you can get it. Question from Miguel is there a lot of negotiation for house on foreclosure or short sale? And you're talking about a lot of negotiations such as on the realtor's side? On the realtor side, okay. I'm good at translating some of these questions, yes. So on the realtor side, if there's a lot of negotiations. So if the house is in foreclosure, at auction, we don't get involved because you're not licensed to go to auction and get paid through the brokerage or anything like that. After the auction, when it becomes an REO, which is real estate owned by the bank, you could be part of it, but now it's a regular sale. It's treated as a regular sale. Where there's a lot of negotiation is exactly at short sale, because you're trying to negotiate with the lender to allow the property to be sold at a lesser value. Okay, so you have to show the lender that the properties in the area are worth less. You got it? So there's a lot more work for you, and there's the cost of calling there, and pretty much is like a pre-approval. Actually, it's even worse than the pre-approval to buy a house. They ask you for so many docs, and every 30 days you have to submit updated docs and all that stuff, that it does take a longer period of time to get everything approved. So there's nothing short about a short sale negotiation. No. It's a very long process where a regular transaction could take, let's say, 2-3 months, right, on average. I usually say 3 to 4, but right now averages is 2-3 months to close. A short sale could take 6 to 10 months to close on average. It could be less, it could be way more. All right, so there's a lot more effort into these. Good? Any other questions? Questions? Nope. Stephanie was like, move forward. All right. So, if there's no questions, we're going to move forward. We have here Leasing Essentials. Leasing Essentials. What are we talking about when we talk about leasing? We're talking about renting to somebody else, correct? So there's a landlord, there's a tenant. And when it comes to leasing, Mealy says, I'm here, need 5 more minutes. You were supposed to be here at 5 o'clock at my office with coffee. That's what I remember from yesterday. Guys, remember that? Some people said 9 o'clock. Ingrid shows up. I said 10. She shows up almost at 12. Right? Francielli says 2:30. Shows up 2 hours earlier. Okay. Right? And Millie, you're supposed to bring coffee. What happened? If I fall asleep halfway through, you guys already know. It's Millie's fault. State send you to Monmouth. Okay. Okay, fine. State mandated. Okay, fine. Francielli says, good memory. I try. All right, good. So, Millie, we're gonna move forward. Okay, so I can't wait to start, but there's not much in the beginning, so you got your 5 minutes granted. You're now down to 3 minutes. Just saying. So leasing, there's a lot more to leasing than just landlord tenant. There's certain rules, certain rights that people have, whether it's the landlord or the tenant, that they have in the contract. Okay, there's different types of leases which you need to be aware of. There's residential, there's commercial, there's leases for industrial, for retail. So there's a lot of different types of leases and lease structures as well. There's a default, which is if somebody stops paying, right? For instance, or if somebody breaches the contract, whether it's the landlord or the tenant, there's a lot of things to take care of. And then this is the nationwide portion, as you guys know. And then every state has their own rules as far as rentals, right? So here's where we start. A lease is both an instrument of conveyance and a contract between parties to uphold certain covenants and obligations. Now, covenants, we're talking about promises, okay? So a lease is an instrument. You guys by now should already know, where's my pen? Should already know what these words are, right? Let's put it on the screen again, because again, by repetition is how we learn things. Francielli told me today that I talk a lot. I have to. I have to keep repeating things. Can you believe she actually came here to the office just to tell me I talk a lot? Right? Unbelievable. But anyway, I have to. So, right here we have instrument. Who can tell you what instrument means? You should know this stuff by now. Documents. Yep. For real estate transaction, documents. So it says here that a lease is a document, right? Both a document of conveyance. What is conveyance? Transfer. Great. Great. So instrument is a document of conveyance. Why? Because it transfers certain rights or benefits to the tenant. So if you guys remember, yep, a voluntary transfer, perfect. If you guys remember, we talked about owning a property. You own a bundle of rights, right? And there's 5 fundamental rights that come with it. You have the right of possession, the right to use the property in any legal manner. You have the right of enjoyment, right? You have the right of exclusion, and you have the right of disposition, or, as we kind of ended, alienation. You guys remember this? Right? So you have these rights. What is alienation? Disposition or alienation is to gift or sell the property. So these are the rights you have. In this case, it transfers two rights to you. The right to use the property, enjoyment, three rights. Use the property, enjoyment, and the right of exclusion of the of anybody except for the landlord. You can exclude anybody else from entering. The landlord, with certain conditions, the landlord can come into the property. And you also have the right of possession of, or it's implied right of possession to the property that you just leased. All right, so you have almost all the rights with a lease. Now, it's also a contract. What is a contract? A contract is an agreement between two parties. So not only it's a document that transfers, but it's also a contract that determines what are your duties, your rights, and obligations with it. Okay? Arelis, you can hear me now? Arelis, let me know. Okay, good. All right. So, a conveyance, transfer, right? A lease conveys an interest, like I said, it conveys an interest, not all the rights. It conveys an interest or a benefit called leasehold. You guys remember leasehold and freehold, right? Leasehold, right? But does not convey legal title. What does that mean? You are able to occupy the property, but you don't become the owner of the property. Your name is not going to be recorded as owner of the property. The deed does that. A lease doesn't. Gives you the rest of the rights except for legal title. So for this reason, a leasehold estate, leasehold, is also called a less than freehold estate. That means you don't have full rights to it. You have some rights. There's four principal types of leasehold estates. This one right here, the first one, is the most complicated one to understand, which is the estate for years. The estate for years comes with a specific or definite lease term. What is an estate for years? There's a check-in, there's a check-out, right? We talked briefly about this before, right? You guys remember? There's a check-in, there's a check-out. So if I have a 1-week lease, then I already told the landlord I'm coming in on Monday and I'm leaving on Sunday. So it ends on that particular date. Check-in, check-out. Beginning date, ending date. Absolutely. So we're going to write here, again, like I did previously. Check in, check out. So think about Airbnb. Think about going to a resort, to a hotel. And the same thing applies to residential. If I stay there for 1 year on the property, I have a 1-year lease. I'm telling you that I'm coming into the property on 9/17/2020, right? And I'm leaving the property on 9/16, right? At the end of 9/16/2021. So that's my check-in date is today. My checkout date, it's predetermined to be a year from now. And we're going to go over this again in a little bit. Right now it's just a quick overview. The estate from period to period. That's everybody knows as the month-to-month rentals. But there's also week-to-week and there's year-to-year. It could be even a daily rental, day-to-day. You pay per day that you stay, right? So from period to period, automatically, very important, automatically renews as long as you're collecting money. Okay? Until somebody gives a notice, as a landlord, give you notice, hey, I need the apartment, or until the tenant tells you, hey, I'm leaving, it keeps on automatically renewing as long as the tenant is making the payment. Okay? And then we have these two, estate at will, estate at sufferance. Very simple. At will, I allow you to stay, continue for an indefinite period of time. At sufferance, you're there. I'm suffering because you're there without my consent. Okay? It's when I have to evict you. You're overstayed, for instance, or you're causing problems. You're not paying the rent, you're disturbing the other tenants or the community, whatever, and I'm getting complaints. You got to go. Right? At sufferance. You need to go. Now, the legal essence of a valid lease is that it conveys an exclusive right to use and occupy the property. We already talked about this, for a limited time in exchange for rent, so payment, consideration, in exchange for rent, and return of the property after the lease term is over. Now, leaseholds estates are distinguished from freeholds by their temporary nature. So when you see freehold, it's mine for a lifetime or forever, meaning I can pass down to my heirs. If it's a leasehold, it's for a temporary period of time. It could be undefined period of time. So again, month to month, it never ends, right? Until somebody gives notice. But once you die, the lease dies with you, as an example, right? It doesn't pass along to your heirs unless the landlord agrees for that to happen. So whoever's named on the lease, contract ends. So very important you guys remember this. If you move somewhere else, landlord cannot demand anymore. You no longer have rights to the property either. Okay. Cover all this. You guys, I'm sure you already know this. Landlord is the lessor, while the tenant is the lessee. And now let's talk about the tenant's rights. These are basic rights, by the way, and each state has, again, different rules regarding the rights, but these are fundamental. For instance, a lease conveys a leasehold interest or estate that grants the tenant the following rights during the lease term. So very important. Like I was saying, during the lease term. After it expires, you no longer have this right. Exclusive possession and occupancy, right? Exclusive use, quiet enjoyment, and profits from the use. The profits from use, we're talking about commercial, obviously. In residential, for you to sublease to somebody else, you have to have my approval as if I'm your landlord, okay? In commercial, we know that you're doing that for business and you can run your business here and whatever money you make, great, it's up to you. But residential, you might not have this right. Usually it's restricted unless you have the express authorization of the landlord. Again, the tenant has a sole right to occupy and use the property without interference from outside parties, including the landlord. Remember I said that as a landlord, it's my property, I'm entitled to go in? Okay. A landlord can get into the property, that's not a problem. But it has to be for specified purposes, such as inspections or some type of emergency. I cannot just grab my keys and walk into your house. I cannot do that. I have to give you a notice, right? And that notice must be at least 24 hours in most states, okay? Now, if, I thought I had this on silent, it's on vibrate. Hold on a second. You're listening to something vibrate I was about to say. Their phone is really loud back there. All right, so it says right here that the landlords cannot do anything outside the lease's express provisions that would impair the tenant's enjoyment of income deriving from use of the premises. I cannot block you from making money in your business by installing something else in front of your business. As far as residential, again, I cannot go into your property unless it's an emergency or giving you enough notice, sufficient notice. If there's a fire, I'm sorry, I'm coming into your apartment, it's an emergency, right? Other than that, I have to let you know, hey, on day such and such, I will be coming into your property. Please be there. If not, please allow me to come in. So I still have to ask, even though it's my property, for that period of time, that you're renting, it's your property. You guys got it? So no landlord can go into somebody else's property. The lease defines the tenant's obligations, which principally are to pay the rent on time. Everybody knows this. That's why it's not highlighted. Maintain the property's condition and comply with rules and regulations of the building. The landlord's rights and obligations. In conveying the leasehold estate, the landlord acquires a leased fee estate, which entails the rights to receive rent, obviously, to repossess the property following the lease term, so when it ends, it's mine again, and to monitor the tenant's obligations to maintain the premises. These are all common sense. I did not highlight on purpose. I think everybody knows these basic ones. Okay? Now, the lease defines the landlord's obligations, and every state, by the way, has a rule regarding this as well, which is renting a unit comes with the implied warranty of habitability. What does that mean? You need to provide the necessary building support and services, and you need to maintain the condition of the property. You have to be able to live there and not be afraid that something's going to happen to you. All right, so if there's an infestation, landlord needs to take care of. If there's water damage that could affect your personal property, landlord needs to take care of. If the heating unit is not working and we're in the middle of winter, landlord needs to take care of, right? If they provide the heat, that's what it is. Death of a tenant of landlord, I already addressed that, ends the terms. Conveyance. We're going to go over this in a different chapter. All right, we got Vanessa on YouTube. Hey, Vanessa. So we're going to go over this in a different chapter more in detail, but right here it says that a landlord may sell, assign, or mortgage the lease fee interest. Okay. However, transferring a leased property, I don't have it highlighted, but you guys should know, does not extinguish the obligations and covenants of the lease. What does that mean? If I own a property and I have a tenant that has a 2-year lease, for instance, and after 1 year I sell the property to somebody else, the new landlord cannot kick the tenant out. The new landlord cannot raise the rent. The new landlord cannot modify anything that's in that original lease. You guys got it? Just because we sold it doesn't mean the obligations changed. So very, very important. Buyers and creditors, so the new landlord and the bank, must take their respective interests subject to the terms of the lease. And we'll talk about it again in a different chapter as well. All right? So I'm sure you guys have heard situations like this where somebody buys a property and starts knocking on the doors and say, hey, I'm the new landlord, get out. You probably heard situations like this. It happens a lot with auctions. People go buy a property in auction, they win the bid. They don't even have what's called a sheriff's deed, or a trustee's deed, which transfers to your name. It's not even under your name yet. But you're already knocking on that door and say, hey, I'm the new landlord. I need this unit. Get out. Or, I'm the new landlord. Your rent is now $2,000 instead of $1,000. Right? You can't do that. You have to honor the existing lease. Muslima says, unless the landlord wants to move in. So we're going to go over that as well, but every state law has different rules. For instance, in New Jersey, you still have to give enough time notice saying, hey, I'm buying the property, I intend to move in. If it's auction, then after you buy it, you have to give them enough time to move out of the property. So every state has different rules, right here, different rules regarding that. Conditions for a valid lease or a valid contract are all the same. Everybody must be of sound mind and of certain age, depending on the state, like New Jersey has to be 18. And there's some other requirements for the parties. You must identify, notice that this is in yellow, so this is important to pay attention to. The lease must identify the legal description of the property. What does that mean? Well, I need to know what I'm entitled to occupy. I have 1,000 square feet of space in building A, right? As an example. And it's suite 301 as an example. That's my 1,000 square feet that I rented. It could have been 500 feet in suite 301, and then somebody else has another 500 feet and so on. But I'm renting 1,000 square feet in this particular property. So it has to identify what the property is that you're getting. Exclusive possession, that means the landlord must provide an irrevocable right to exclusive possession during the term of the lease, provided that the tenant meets all obligations. And then legal and permitted use. You cannot rent a space to do something that's illegal, right? I think everybody knows that. And the use that is legal but not permitted does not invalidate the lease, but constitutes grounds for default. Meaning, the landlord can still evict you if you're doing something that's not within the terms of the lease. If it's illegal, you're done, you're out. If it's legal but not within the scope of the lease, for instance, I rented this space to be a school where I'm at. If I turn this into a cafe or something, is that what the lease states? No. So now I'm doing something that it is legal. I can put a cafe here, but it's not permitted according to the terms of the lease. You got it? So whatever you rented it for, that's what you're going to do. Verona's question is, can you add a contingency on the purchase and sale agreement or contract? At least I assume that's what P&S means. Prior to buying a property with tenants, if you want them to vacate the property. So here's the thing. The answer is yes, and the answer is no. Because there's an existing lease, you can put whatever offers you want. You can demand whatever you want. Doesn't mean that the seller has to honor everything. So if there's a tenant that has a long-standing lease, then the landlord has to ask the tenant if they're willing to move out. Is the tenant obligated to move out? No. So can you buy a property and not be able to move into the property? Sure. It all goes into the attorney's reviews and agreements, right? So that's part of negotiation. Can you pay for the tenant to leave? It's called cash for keys, incentives. So that could happen. But are they obligated to leave? The answer is no. All right, guys? Rowan is typing a little bit more. Let's see what comes. That's what I said. Unless you have to ask. So it's an agreement. You don't have a right to kick them out. You have the right to demand, but that demand does not have to be met. Like there's a lot of times I go to buy a property and I say, hey, I want it vacant, fully vacant. Depending on what I'm going to do, I want it fully vacant. But they have the right to say no. As far as this right here, what you just wrote, hold on, for you guys. The 30 or 60 day notice, I was already mentioning that earlier. The 30 or 60 day notice depends. If you intend to move in, right, you're going to occupy one of the units or whatever it is, if it's a single family, you're going to occupy the whole single family. Then you must prove that you will actually do that. Because there's a lot of landlords, and especially certain states like New Jersey, they're pro-tenant. So if you intend to get somebody out and they say you're moving in and all of a sudden you're renting to somebody else, and there's a lot of stories like this, especially here in Newark, right? You rent to somebody else, why? Because this person is paying $1,000 and you know, buying this property, you know if you kick them out, you can get anybody at $1,500, at $2,000, whatever. Does that make sense? So you cannot give a notice just because and please get out. No, it doesn't work like that. It depends on the state. The state of New Jersey is one of the states that says, nope, can't do it. Unless you're actually moving in. And if the tenant that you just evicted, if the tenant finds out that you did not move in, that you rented to somebody else, they can actually take an action against you. Yep. All right, so be very careful with that. Always consult a lawyer, whatever your situation is. That's very important. Always consult a lawyer. And one of the things that I advise you guys is consult a lawyer that's specialized in real estate. All right, don't consult a lawyer that specializes in divorces or a lawyer that specializes in corporate documents. Don't do that. All right, it's the same thing as going to your general doctor right? Your family doctor and say, hey, I just gave this example today to a student that was here. You're going to go to a family doctor. Doctor says you have a heart condition. Well, what should I do? You ask the doctor, right? Do you think the doctor should give you that answer or send you to a cardiologist, to the specialist? You see what I'm saying? So don't go to any attorney. Go to the one that's specialized in that field. Very, very important. Okay? And especially because state laws differ and each municipality can even be stricter than that. Okay? That is my question. My friend had just moved into a new... This is your question from yesterday? Yeah, the question... Yeah, it is. Okay. I don't know if you guys remember yesterday, Teresa, and I told you that Teresa's the one with the stories. Right? Yesterday she goes like, I have a question, but I think it's for tomorrow's chapter, so I'll leave it for tomorrow. Okay. Here's the question. So, my friend had just moved into a new home, and 3 months later, the landlord sold the home and gave him a 60-day notice. And she just moved to the area. Okay. And what was the notice? Was it the notice that the new landlord was moving in? What kind of notice did you get? Let me know. To leave the home. Did they leave? No? This is happening now? Oh, right now. I thought it was only you with stories. So stay away from me, Teresa, because your stories scare me. I mean, you and your friends, I don't know. All right, so 3 days ago, there might be grounds for a lawsuit. There might be grounds for a lawsuit. First of all, contracts, depending on the state, you have up to 6 years to sue in the real estate transaction. That's one thing. Second thing, if the landlord did not notify the tenant that they had intentions of selling the property, right? If the landlord did not notify, then the landlord acted in what's called bad faith. Acting in bad faith could result in several penalties for the landlord. Okay, so she needs to get an attorney. Got it? Cool. But anyway, always consult an attorney because again, every state is a little different. Yvette. So if the lease said month to month is one thing, if the lease said 1 year is another, but still acted in bad faith, especially when it's a brand new lease. Okay, I should have told the tenant. Okay, so now it comes down to that. Law is law, I got it, but bad faith comes with penalties. I should have told the tenant, hey, you can move in on a month-to-month basis because I don't know what's going to happen with the buyer, but I am selling the property. If the buyer moves in and wants the property to be vacant, you have to honor that. You understand? So it depends on the lease. Sure, month to month, and you've been there, you've been established, and all of a sudden I give you a notice to get out. Maybe I can. Okay? But regardless, she just rented it and the property got sold. Bad faith. Okay? There's a few things we're going to mention today that it could be bad faith, and each state looks at it differently. Consideration. Oh, you guys should know this word by now. What is consideration? Let me know. Verona's asking, what is your recommendation when purchasing a multi with tenants and wanting it vacant at closing? Sucks for you. That's my recommendation. If you want it vacant, it's a gamble. You might be able to, you might not be able to. If they're long-term tenants, and then they're on month to month, you can request the property to be vacant, but it's up to the landlord, the landlord and the landlord, the seller / landlord's attorney to send a letter to the tenants that they have to leave. So give them enough notice. All right. And again, now we're talking about the 60-day notice in this case. Gotta give them enough time because they're not being kicked out because of something they did. They're being kicked out because the buyer needs. And again, even there might be some restrictions. So that's why it said sucks for you, because it's a gamble. You might get him, you might not get him. If the rents cover the mortgage, don't be too worried about it, right? You can go later on and adjust. I mean, you can always request. We should always request. That's why I advise my clients. You should always request, if possible, do so, and if they accept, like, it's vacant. If not, just understand that your mortgage is going to be $4,000. You're bringing $5,000 in rentals. You're good. You don't like the tenants? Well, money's coming in. Talk about it later. You see what I'm saying? It's always a gamble. All right, so let's go back to the chat. I asked what consideration was. Muslima, yes, that's what I was saying. Yep. All right, let's see what we got. I asked consideration. E. Stefani, you wrote willing. By the way, don't sue me, okay? I'm just messing with you with the name. It just sounds way cooler, and then we got different Stephanies here. All right. Caring. Christina says caring. Okay. Love and affection. Arelis. Great. Consideration is to act in good faith. No, not here. Exchange of value, and then what friend said. Stephanie M, at least she wrote it right this time. All right, so exchange of value, yes. When we're talking about consideration, I totally understand what you guys, some of you wrote caring, willing, and all that stuff. Like, I consider you to be a great person. Consideration about somebody's actions. But no, here, consideration means money or exchange of value. Consideration is exchange of value. I'm giving you my apartment for you to rent, and in exchange, what are you giving me? Money. You guys got it? So consideration in a contract, whether it's a lease or purchase agreement, okay, it's money or exchange of value. Or in state exam, pay attention, in state exam, look for C. The answer C is what friend said. That'll be the answer. All right. That would be so awesome if that answer was actually there. Sometimes they have these crazy, stupid answers anyway. So imagine what friend said. Click on that. And you guys are going to see in some of the questions at the end of the book, or some of the questions, some of the stuff you might see in Quizlet, gives you different options, different things, and it might just be a totally random question that has nothing to do, answer that has nothing to do with the question, right? But it's there to completely throw you off. All right, next thing we have is offer and acceptance. Just like every contract, there must be an offer and there has to be an acceptance. You guys remember delivery and acceptance of a title? Same thing. Until one of the other party accepts, the contract is not valid. This is true for leases. This is true for purchase contracts. This is even true for wills. I can will a property to you and you can say, no, I don't want it. Right? Once I die, you get the property and you go like, no, I reject the inheritance. So there has to be offer and acceptance to make it valid. Very, very important. Signatures. Let's talk about signatures. Again, every state has their own rules. Notice that I did not highlight it here. But signatures. A contract could be oral or written. A lease could be oral or written. Each state has different rules. I'll give you again the example of New Jersey, and we'll talk about it once we get to the state portion. In New Jersey, if it's a lease for 3 years or more, so if it's a long-term lease, that's what they consider 3 years or more to be, then it must be in writing. But if it's less than that, it could be a verbal. So is a signature needed if it's a verbal contract? No. But if it's in writing, and this is what you have to think, it becomes common sense, but I like to point it out. When you see the question that says a lease that's in writing, then a signature is an obligation. In this case, it's saying that the landlord must sign the lease because he or she is the one that's conveying the property. Just like a deed, if you guys remember deeds, right? Just like a deed, the grantor or the seller is the one that needs to sign. The buyer doesn't sign. So for a lease is the same thing. Whoever is granting the right or permission or interest, whoever is granting is the one that must sign. Should both parties sign? Absolutely. Okay? Should all parties sign? Absolutely. Yvette's asking, if that happens after I die, what happens? Sorry. If what happens after you die? Oh, you're saying that you prepare the will and I'm your heir and I say, no, I don't want it? Okay. Because a will is after you die. So that means you're no longer here, right? And let's say the executor or the administrator, executor if you name somebody, or administrator if the court named, right? If they say, hey, Bruno, you inherited from Yvette, you inherited X amount of dollars and property Y and Z and whatever, the moment they're proclaiming what was your last will and testament, that's my chance to say, oh, that's nice, but I don't want it. Okay? What happens to the property? If nobody else claims it, if you guys remember from yesterday, if nobody else claims the property, it goes to, let me know in the chat. Nobody else claims the property. What happens? Goes to the state, the government, by, what is the term? What is the term? What is it called? You guys are on point. I love it. It's chest. I know somebody that speaks like this. Oh, it's cheat. Got it. Right? No, it's not who you think. No, not Agent Orange. No. No. Anyway, it goes to the state by escheat. Very, very important. So the state cheats you out of your property. Absolutely, Miguel. That's usually what I like to say. The state. Yeah. Pedro just said me. Yes. I was talking about Pedro. I was not talking about anybody else but Pedro, my business partner. Especially after a glass of wine, forget it. Yeah. You don't understand the word he says. Already tough on a normal day, right? But after lunch is terrible. Don't speak to Pedro after lunch, okay? I'm just messing with him to see what he says to me. All right, next. As I said, a contract could be, or any contract, lease, whatever agreements, could be oral or written. Oral or written. So, generally, a lease for a period exceeding 1 year cannot be oral, but must be in writing and enforceable because of statute of frauds. An oral lease or rental agreement is legally construed to be a tenancy at will, having no specified term. Further, an oral lease terminates on the death of either principal. Now, notice that it says here, when you guys go study, it says here, generally. These are keywords you need to pay attention to when you study. If it says generally, does it mean all leases? No, it means as a general rule, right? As a general rule, it should be this way, but there's always a chance of not being. So again, every state is different. In this case, it says generally, if it's for 1 year or more, it must be in writing to be enforceable. Okay? Again, state of New Jersey, as an example, if it's 3 years or more, it must be in writing. If it's less than that, it could be just an oral agreement. Should it be in writing or should it be oral? What do you guys think? Should it be a verbal agreement or in writing? What do you think? If you're on YouTube, if you're watching, give me your opinion as well. Join us. And correct. Writing. Absolutely. Verona, you're picking up skills from the wrong people. Okay? Picking up skills from the wrong people. There's a G after that. All right. So it's been a long day. Yep. I know. I told you I needed to have you in class. I needed to mess with you. All right. So we talked about this. Great. Let's talk about rent and secure deposit. So a rent stipulates the time, place, manner, amount of rent payment. Everybody knows this. It defines a grace period that is allowed and states penalties for delinquency. The lease may also call for a secure deposit. Let's go again at certain words. May also call for a secure deposit. Do we have to have a secure deposit? Do I have to give you $1,000, $2,000 a month, 2 months, 3 months, whatever it is in each state? Do I have to? Word is may. If it says may, it doesn't say must. Okay, it doesn't have to be. So a secure deposit operates as a good faith deposit, right? It's where you're telling the landlord, hey, I intend to follow the terms of the lease. If that fails, you get to keep the deposit. That's pretty much what it is. Some landlords may ask for it. Some tenants may offer it to secure the deal as well, right? You can offer a higher secure deposit if the state law allows you. So it's not an obligation, it's an option that might be asked. If asked, then you can only rent from me if you give me the secure deposit. If not asked, then you don't have to. Okay? And the secure deposit is to protect against losses from property damage or tenant's default. Again, I have it in green. State law regulates handling of secure deposit, where it needs to be deposited, and whether the tenant receives interest on the deposit. Okay, we'll recap later, but New Jersey requires you to put that money into an escrow account that's earning interest, and that interest belongs to the tenant, not to you. All right? A landlord may require additional financial security from a tenant of dubious creditworthiness in the form of personal guarantees, third-party guarantees, or pledges of other property as collateral. Now, this happens mainly in commercial. So when you go rent a commercial space or retail or industrial space, for instance, and your credit is so-so, or the business credit is not established yet, right? Then they might ask for what's called a personal guarantee or a cosigner that has a more stable structure, financial structure, for you to be able to rent the space. Okay, so I'll give you the example. The LLC that we used to open the space where we are right now was a brand new LLC. So the landlord wanted to see a little bit more skin in the game, right? That's what it's called. So both Pedro and I had to give personal guarantee that yes, we're going to stay here for a certain amount of time, that yes, we're going to make payments on time, that yes, this, they asked that. We had to make a personal guarantee. All right, so it's more towards commercial. In residential, it's that security deposit, and that's it. They know that to collect on personal guarantee for residential, it could take forever. Not that in commercial it won't, but it's a different ball games. Like the rules, ethics, and all that stuff is out the door when it comes to commercial. All right, so there's a lot of the things involved. The lease must specify the lease term, meaning if it's a month to month, or if it's a state for years, you must specify what type of lease it is and when it starts, when it ends. Repairs and maintenance. So with repairs and maintenance, I'll go to the messages in a second. So repairs and maintenance provisions define the landlord's and tenant's respective responsibilities, right, for the property repairs and maintenance. Now, generally, as I told you earlier, the landlord is the one responsible for the general repairs, the habitability, right? But the tenant is responsible for routine maintenance. So you're responsible for maintaining the property because you're there. You're responsible for cleaning it. You're responsible for minor things like changing light bulbs, right? If there's a air conditioning, you have to replace the filter, things like that. Traditionally, basic stuff, you are responsible. General repairs that could endanger your life, health, or safety, landlord takes care of, okay? The payment of such repairs is negotiable between the landlord and the tenant. So we might share the cost. I might tell you, hey, up to $100 in these type of scenarios, it's on you. Anything above this amount is on me. So everything is negotiable. All right? Let me go to the questions before I go to the next section. Okay, so just to clarify, Elena, on what you said before, the state does require a secure deposit. No. Nobody requires a secure deposit, but if one is asked by state law, there might be different requirements by state law. So they might ask you, state of New Jersey asks you as an example, to put that money into a special escrow account that earns interest. When we're talking about escrow account, it's a separate account just for deposits, for security deposits. It cannot be mixed with your money. That's what it is. Okay? So that interest belongs to the tenant. And again, once we get to the New Jersey portion, I'll go into that in detail. So if you rent, and we left the deposit, okay, we'll talk about it. There's even penalties if the landlord does not give you your money. There's penalties for the landlord. Okay, Miguel, is it true that a landlord cannot decline pets of the pet? My dog never had a pet. Same. I never had a pet of the pet of the pet. Or are you talking pets of the kids? Like, they belong to the kids, the pets of the pets. Is that it? If the pet is a registered, I'm translating, don't worry. I got you. I just like messing with you guys. Cannot decline or reject pets if the pet is registered as a support animal. Oh, and then you type it correctly. Got it. So if it's an emotional support, if it's a guide or service dog, or a pet, they have to allow, if they're renting to you, they have to allow the pet to come with. But they might charge you an additional deposit and additional rent. That we're entitled to charge. I cannot reject you if it's a support animal. I cannot reject you based on the animal. I can reject you based on other things, right? But I'm entitled to say no pets all day, every day. But if I do allow you, sure, bring a pet. It's an extra amount of dollars towards deposit and an extra amount of dollars every month. Okay? It's like having an extra tenant. You guys good? Give me a thumbs up if you're good. All right. Give me a thumbs up with emotion. All right. Some of you, that thumbs up was like, yeah, I think so. All right, next. Subletting and assignment. All right, YouTubers. What is the delay? Because I just got a reply to the whole in writing or verbal or whatever. I just got a reply to that right now. Interesting. All right, so subletting and assignment. What is subleasing? Guys, you have right here highlighted, so I'm going to give you just a quick synopsis. What is subleasing? Well, I'm the landlord, and I rent to, let's see, to Bianca. I'm going to rent to Bianca, and Bianca says, well, I need to have a roommate. So I'm going to bring Fabiola to live here with me. So now there's two people, but I only rent to one. Only one person is on the lease. So if another person joins the lease premises, then it's called a sublease. Bianca is now adding another person with or without my consent. That depends, and we'll talk about that in a second, right? With or without my consent. But the fact that you add another person right? When you're the only one on the lease, it's called subleasing. Okay, you're adding, you're there and you have more people. What is the problem with subleasing? Bianca, you are primarily liable right here. Primarily liable. What does that mean? It means if Fabiola does not pay you to pay me, I'm not going to evict her. I'm going to evict both of you, but Bianca, you're the one responsible for the rent because you're the one on my lease. You guys understand? So when you sublease, when you rent to another party while staying there, right? Then you are the primary person responsible for seeing the lease paid. In an assignment is a little different. Assignment, right here, this word assignment is a transfer of risk. Okay? So the transfer of risk is, Bianca, you have the lease, and you're like, I cannot move forward with this. I have to leave. I have to go somewhere else. I cannot afford this. But I found somebody to take my spot. So now you're going to assign or transfer the rights or benefits and liabilities and obligations to Fabiola. So Fabiola moves in and says, okay, landlord, I'm the one substituting Bianca. So Bianca's no longer here. It's me now. What is the problem with an assignment? With an assignment, see, Fabiola now has primary liability. So she becomes the assignee, which is Fabiola in this case, becomes primarily liable for the lease and the rent. Why? Because she's now the person that I'm renting to. But because she rented during the term that Bianca was supposed to rent, Bianca is also responsible. She now has what's called secondary liability. So in a sublease, Bianca, in my scenario, was fully liable for the rent. In an assignment, Bianca has a secondary liability, meaning she could be in the back end, and if one does not pay, I sue both. You got it? In sublease, I'm going to sue that one person that I rented to. Did you guys get it? Good? Thumbs up? Great. Verona's asking, does this have to be approved by the landlord? So most leases will have a standard notice about subleasing or assignment. Most of them will say subleasing or assignments not allowed unless approved in writing by the landlord. So most of them will say landlord must have knowledge of this. Yep. Okay. Right here, improvements and alterations. You might be able to make changes to the apartment. You might not be able to make changes. One of the things you need to know is that any improvements that you make become property of the landlord in absence of an express agreement to the contrary. What is an express agreement? Well, any alteration you want to do to my unit, because remember, I'm your landlord. Any alterations you want to make to my unit, you have to ask me for permission, and I have to expressly allow it. So I have to say yes or no. You can do this or not do this. And what's going to happen after you leave? Meaning, if you leave, do you have to restore the property or do I get to keep the property? Does that make sense? So if you don't say anything, then automatically becomes mine. Go ahead, fix whatever you want in my house. Go ahead, install new things in my house. Do whatever you want. If it's going to improve, I'll accept it. Right? If you don't tell me anything, it becomes mine. If you tell me something, I will explain to you what we do after you leave. Will I compensate you? Will I return it to you? Or will I just keep it because I am the landlord and I have that power? Again, right here. You guys got it? So if you're a tenant, careful in what you're doing in the house without permission. Like if you replace a stove, as an example. If the old stove becomes damaged, the old one that you removed, first of all, there's no proof because you didn't get my permission. There's no proof that it was not working, right? So guess what happens? You put a new stove and you put my old one there when you leave? I'm entitled to the newest and best. Because you did not get my permission to replace something that was mine, that newest and best stove is now mine. You guys got it? Very, very important. Make sure you get something in writing. Everything should be disclosed. Everything should be in writing. Your life should be in writing. I mean, certain things, okay? Whatever you do in your diary, keep it private. But certain actions where it involves another party should always be in writing for your own protection. Erica, how would the landlord know? Well, there's a lot of landlords that don't care, right? But there's landlords like me that once in a while show up and say, hey, I'm here. How are you? Just wanted to see if everything's okay, if there's any damages to the property, that it needs to be fixed, any maintenance that needs to be done, let me know. Or, great question. They put the old stove. What I was giving you my example was the old stove no longer works. So as an example, I gave you the stove working. You rented, everything was working. Now the stove does not work. Why did it stop working while in your hands? So that's another way. All right. So I'll give you an example. I just went to, I told you guys I went to Portugal a couple weeks ago. And one of the first things I did when I got there was send a message to my tenant and say, hey, I'm in Portugal. Do you mind if I pass by? Simple. I went there, checked out the property, got to meet the tenant. I didn't know him. So I got to meet the tenant and his family, right? And I checked the property. So now I know the condition of the property. Simple. How do I get to know? I know they made changes, right? And then what I do with those changes is up to me. Will I allow it? Will I give him credit? Will I make him restore the property to original condition after? That's totally up to me. Okay? Question. Who's responsible to replace if the stove no longer works? Take a wild guess. I gave it to you, was working. You never told me it stopped working. I do a final walkthrough with you and it's not working. Again, you never told me it was not working. So now it doesn't work. I found out. Take a wild guess. Oh, plus, here's the other thing. I'm sure. Known. Yes, I should have known. Okay. So I have this right here. So I glanced and I see I should have knee. Okay. Whatever works. You should have known, yes. So the other thing is, look, if you install something new and you remove something old, I don't know if you ever tried this in your house or not, put something new in your house. Are you able to tell that something is different in the house? Even if you put back the old one or you replace later for something else? Can't you tell that? I'll give you the example. We made so many moves here in this classroom in order to make this work. The whole Zoom and then eventually online and physical classes. We make so many changes here, right? That you can tell that something was not here, that something changed. You can tell even by coming here, you just look at the walls and you're like, okay, this was not here. You just installed it, didn't you? It's easy. So what if they call you during the term of the lease and say the stove, fridge doesn't work, who replaces? Okay. So now comes the question. And guys, we're going to move forward from this, but it becomes now a matter of common sense as well. Now comes the question. When I gave it to you, how old was the stove? Did I know that it was going to eventually stop working? If it was brand new and stopped working, it's either under warranty or maybe you did something. And I've had tenants where when they moved out, I had to have somebody specialized to come move in and clean that stove, right? As an example. I've had tenants that brand new stoves and I had to replace the stove when they left. So some people don't take care of their stuff. I've seen houses where I bought an auction property a while back, and let's just say they're still a few feet above me. But let's just say that at this height, there were marks on the wall of stuff that shouldn't be in the room. Should be in the bathroom. How did it get up here? And all over, smeared. So how did it get there? So the point is, some people really don't take care of things. So who replaces it? Now it's a matter of finding out the habits. Was it because you used it improperly or did not maintain it properly? Or was it because it was old and needed to be replaced anyway? So who pays, me or you? That's where we go with it, okay? And then there's this. It's exactly what I was saying right now. Like, I've had people that damage it, but if they pay their bills, they're always on time. What is the price of a stove? Come on. It doesn't have to be the $3,000 stove, right? It doesn't have to. So just put something there if they're on time. You guys good? And Carlos? Yeah. You. Oh, Vanessa, if you're watching, this is for you. I did. Lol. All right. So this is a new word that I've learned that is now used in English as well while conversating. Not through text messages anymore. It became a valid word. So every time you guys want to laugh with somebody else, you just say lol or lol. All right. So it's not for text anymore. So Muslima says, I did. I was a refrigerator and I was annoyed. Annoyed by what? That you had to replace? If they paid it, if they're paying on time, you know, damage is damage. It's wear and tear. Just deal with it. Okay? All right. Next. Options. An option clause offers a tenant the opportunity to choose a course of action at some time in the future under certain terms. Typical options are the right to renew the lease, buy the property, and lease additional adjacent space. Here's what I want to say before I read the last sentence. Options. We're talking about lease options, or are we talking rent options? When you go rent a car, you have the option, lease a car, let's put it like this. You have the option of renewing the lease, right? You have the option of buying the car at the end, correct? Yes or no? So these are options that you have. You don't have to, as a tenant, you don't have to renew, or you don't have to buy, if that was the condition, rent to buy or rent to own. You don't have to buy. But the landlord, this is very important, it might be a question in school or state exam, the landlord must comply if the tenant does exercise this. So an option agreement, we'll talk about it later, is a unilateral contract. What does that mean? One party must do something in order for the other party to comply, right? If it's a bilateral agreement, both of us have to do something. So an option is the tenant does not have to buy, but if the tenant says, yeah, after 1 year, I want to buy, like he now exercises the option to buy, then the seller has to sell. Again, let's look at cars. Can the dealer sell the car to somebody else while you're leasing the car? The answer is no, they can't. While you're leasing, and this is only in options, okay? While you're leasing, they cannot change the terms that you have. They cannot sell it to somebody else what you're supposed to buy, as an example, okay? Any questions? Cool. Types of leases. Types of leases. We have gross lease. We have net lease, percentage lease, residential, commercial, ground lease, proprietary lease. So there's different types of lease depending on the purpose, okay? So it's very, very simple, very easy to understand, because a gross lease is like your paycheck, okay? Gross lease is like your paycheck. There's the amount that you wish. I'm sorry. So gross means you're dealing with the bulk. I'm sorry. You're dealing with the bulk. Gross. So there's the gross pay, which is the amount you wish you would get, right? But then there's expenses. So the landlord collects the rent, right? But still has to have deductions. So the landlord still has to pay for taxes, insurance, for maintenance. That all comes out of the landlord. So your employer, for instance, your employer gives you a check, and then there's deductions that you have to pay for, Social Security and so on. Here, you pay the landlord $1,500, and the landlord still has to pay for something, so deductions. And this is more common usually in residential, with the exception that tenants often pay utility expenses. A net lease, the next one, a net lease. A net lease is you guys now dealing as independent contractors, as an example. Once you become a realtor, the broker is going to pay you the full check. It's yours, right? But now you are the one responsible for paying an additional fee, which is your own taxes, your own insurance, your own maintenance. In a net lease, the tenant pays a flat fee plus the utilities, the taxes, the insurance, all that stuff is paid. It's called triple net, right? So a net lease requires the tenant to pay for everything or a portion of it, okay? Here, you don't deal with taxes, you don't deal with insurance, you don't deal with maintenance. Here, net lease, you might share utilities in common areas, you might share some repairs, you might share taxes, insurance, maintenance, and so on. So net leases, it's a flat plus a few other things, okay? These are common for office and industrial properties. The next one we have is called percentage lease. What is a percentage lease? It's very similar to the net lease. Yes. Coffee time. I love these people. Thank you, Myron. You are the man.
Hey guys.
They're saying hi to you. You're leaving?
Yes.
You bring me coffee in your house?
Somebody has to work out there.
All right. Did everybody leave? Okay. Cool. Thank you so much. Appreciate it. For Verona, no. Realtors pay insurance and maintenance. Not getting it. Oh, what I was telling about the example. Oh, so what I was saying, we're going to talk about that later as well. What I was saying is you have employee, you have independent contractor. As an employee, right? Your boss is going to pay you, right? But then you're responsible for those deductions. So the boss pays you $2,000, and then you see on your paycheck they deducted a bunch of stuff, so what you take home is less. In a gross lease, let me go back. The example I was giving you is the tenant, let's say it's your boss for this example, the tenant pays you, but then you are responsible for those deductions. You got to pay taxes, insurance, maintenance, and so on. So are you taking home whatever the tenant pays you? No. Here, in the net lease, the example I gave you is your broker pays you a check in full, no deductions. You are now responsible for paying for your own deductions. In the net lease, the tenant pays that payment, right, the $1,000 or $2,000, and they are responsible also for paying taxes, insurance, maintenance, and so on. So they pay above whatever their rent is. So it's that payment plus something. Here is a payment in full, and the landlord deals with it. In this one, the percentage lease is just like a net lease, but a little twist to it. It's very simple. I want a portion of your business. Okay? So percentage leases are usually for retail properties, right? But a percentage lease is where I get a fixed percentage of your gross revenue with a minimum rent. So every month, I want $1,200, okay? But if your business makes more than, let's say, $30,000 a month in gross sales, I want 5% of whatever you make, okay? Another way it could be is minimum rent, percentage rent or minimum rent, whichever is greater. So I want $1,200 or 5% of your gross business. If your gross business is more than $1,200, then that's what I want to get paid. If your gross business is less than $1,200, then that's the minimum I want to get paid. So these are the three different ways that percentages might work. Okay? You guys good with this? Thumbs up. Great. All right. Commercial lease. We're not going to get too much into this, but you guys understand what a commercial lease is. It could be net, could be gross, could be percentage lease. Traditionally, it's a net or percentage lease. That's the most common. It could be a very long-term leases, so 25 years, for instance. The tenant usually does the improvements because it's for business purposes, right? So they usually are responsible for any improvements to the property and so on. A ground lease, okay, so jumping commercial lease, ground lease is also called a land lease or terra lease, means land. So a ground lease is, let's say I have a 25 by 100 lot, 25 by 100, just land. Let me put it here right now. I think there's a huge delay on YouTube. My student on YouTube just laughed at the comment I made about 10 minutes ago. The lol comment. Because that's the student that made the comment today. All right, so let's say here, this is the road. And I have this piece of land right here. This is my lot, right? This is the piece of land. Now, a ground lease or a terra lease or a land lease is where what I'm renting to you, right? What I'm renting to you is this space, just the land. And I'm renting for $1,000 a month. Now, what I'm gonna let you do with a ground lease, because I'm just renting land, I'm gonna let you build on it. Okay? So you're gonna put whatever the building is, you're gonna put it right here, okay? So this is your building. So tenant builds. Cool? The tenant is responsible for building anything on it. It could be a gas station, it could be a strip mall, it could be a Walgreens, it could be whatever. I'm just telling you that as a landlord, I'm renting the land. It's a ground lease. Whatever you put on it just has to be approved by the town. I don't care. You pay me my $1,000 a month, or my $10,000 a month, or my $20,000 a month, whatever it is that I ask you. And then you are responsible for building. And traditionally, these are triple net leases. What is a triple net? That means you are responsible for taxes, insurance, and maintenance on top of building. You guys got it? The tenant pays all taxes. Yep. It's a triple net. So you guys understand? A ground lease, if you hear ground lease, we're renting land. What do you do with it is up to you and whatever the town approves. I'm okay with it. Just pay me my $1,000. And my $1,000 is clean. You are responsible for taxes, you're responsible for maintenance, you are responsible for insurance, everything else. Okay? Is that cool? Easy? Now, should this be a 1-year lease? No, it doesn't make sense, right? It doesn't make sense. Why would it be a 1-year lease if I'm going to build on it? Building could take 1 year, depending on what it is. So these leases traditionally are very long-term leases to make it reasonable for somebody to improve your land. So these could range from 30 to 50 years. It could be even 1,000 years. Francielli just wrote, many CVS and Walgreens do that. Absolutely. There's the Walgreens here in Newark that pays almost $20,000 a month. Just the ground. $20,000 a month. Imagine being the owner of that land and every month you're collecting $20,000 clean. Just to have a Walgreens on it. Okay, crazy, right? All right. Proprietary leases, you guys already know what it is because we talked about it yesterday when we mentioned condos and co-ops, right? Yesterday, no, 2 days ago. Condos and co-ops. So, proprietary lease, you have a leasehold interest with no limit, so no ending, right? As long as you are the owner of the co-op. So that's a proprietary lease. All right, leasing rights, we already talked about it. Default and termination. Okay, where it says default and termination, guys, every state has their own rules. Again, we're talking about national rules, or what's the common rule across the board, okay? But every state determines what remedies you have. In fact, most states have some type of, as New Jersey has the truth in renting, or rules and regulations about renting for landlords and tenants. And some states force you, like New Jersey, again, because we are mainly in New Jersey. That's what this course is for right now. New Jersey says you have to present that to the tenants. Have to. It's not a you should know. No, you have to present to the tenants what are their remedies in case the tenant defaults or in case the landlord defaults. What are causes for lease termination so the tenant can avoid it or understand why the landlord is evicting them, and so on. So all these are part of that pamphlet that everybody should have. So, remedies for default. If a landlord or tenant violates any terms of and covenants of the lease, then they are in default. In the event of default, the damaged party may pursue court action, including suing for damages, cancellation of lease, or specific performance. Okay. What is specific performance? This word is going to pop up in contracts, always in contracts. Whether it's a lease contract, it's a purchase and sale agreement, if it's a mortgage contract, there's these words. Specific performance means forcing somebody to do whatever the contract says that they were going to do. So if I'm selling or if I'm renting to you, right, that was my promise. So I have to perform whatever I promised. If you are buying or if you're renting from me, then you have to, again, perform whatever your promise was. Does that make sense? The word specific performance means to perform the terms of the contract. Whatever we mentioned that it was supposed to be the mutual agreement here. Okay? So it compels a defaulting party to perform the contract obligation that was breached. For example, if a landlord fails to replace carpeting as promised in the lease, then a tenant can sue to obtain the landlord's specific performance of installing a new carpet. If the tenant defaults, right, which most commonly happens from failure to pay rent, that's the most common one, the landlord may file what's called a suit for possession. This is also called the actual eviction or suit for eviction, right? An eviction is a dispossessed proceeding. Why? You are in possession of an item. Again, the mouse, right? You are in possession of an item. In this case, the item is the space that you're occupying. I'm going to sue to evict you, meaning dispossess you. So rip it out of your hands, dispossess you of that property. Rip you out of your hands, take you out of that property. That's what a dispossessed proceeding or eviction actually is. So then I have the right to repossess the property and kick you out and maybe sue you even for damages. All right? So you need to understand the separation here. The eviction is to take you out of possession, dispossess you of something. And then I also have the right to sue you for damages. That's a second option. Okay? What are damages? Non-payment or damages, physical damages to the property, which cost me X amount of dollars to fix. So the first lawsuit is just for me to repossess the property, to get back in. And then the second lawsuit to collect my money. All right? A lot of people don't understand that, and my very first tenant was my very first experience of understanding this. My very first tenant led me to evicting, right? And then realizing about a year later, realizing I'm not getting my money unless I put another lawsuit. So I thought, well, I got the judgment, the judge approved the eviction, so I'm getting my money. I sit back, relax, let it be. That's what I was thinking. I did not use an attorney, so you guys know. So a lot of things I did not know. And then a few months went by, and I'm like, no money. I started calling the court. People said that I needed to go to court. I'm like, yeah, I already did. So nobody was helpful at the time with these questions. Then I finally had a friend of mine, which happened to be an attorney, and explained to me, no, Bruno, the eviction process or proceeding was just to kick them out, to allow you to go in. That's all. You want money? You need to sue in the small claims court to get the money. And I'm like, oh, I already avoided paying an attorney because I couldn't afford an attorney at the time. First property, it was, if I tell you guys the whole story, it was bad. But the first property was a horror show. I already could not afford an attorney, and now you're telling me that to recover my money, I have to get an attorney? It says, listen, my honest opinion, if it's less than $10,000, just move forward. Next. Rent it to somebody else, eat up the cost, whatever loss you had, and that's it. Just move. That's what I did. I lost that money. But you know what? I learned how to prepare better leasing agreements. And I found another lawyer, not my friend, because my friend charged me a lot. But I found another lawyer that specialized in evictions. And I used them for 1/3 of the cost that my friend, very good friend, dear friend, was charging. So always remember this. If you have friends and family, always charge double or triple. Anyway, moving forward. That was eviction. Before filing suit for possession, depending on the reason for eviction, you must give a proper notice. Okay. Here it says, notice to pay money. This is not with every state. I'll give you a heads up. What happened to me back in 2005, my first investment property. What happened to me in 2005 was Google was not around back then. So there was something, I don't know if you guys remember Ask Jeeves. Anybody remembers that? Okay, cool. So I asked Jeeves. I said, Jeeves, hey, here's the problem, man. I need to evict somebody. They're not paying. What should I do? That was the Google back then. Like, ask Jeeves. Tenant not paying, what to do? And Jeeves said, you have to give him a notice. I'm like, okay. Do you have a template? Obviously, the conversation wasn't like this, okay? Jeeves doesn't talk like that. It was not that advanced. So Jeeves says you have to ask for a template, a notice to pay or quit. So this is what I asked for, notice to pay or quit. And he gave me one, a template. But the template was from Virginia or something like that. I even forgot which state it was. State of New Jersey, as an example, does not require a notice for payment of monies. State of New Jersey, you don't pay by the due date, next day I can be in court, filing against you already. If it's something else, Erica's laughing. If it's something else, then you need to give notice. Like they're disturbing, they're damaging property, you have to give notices. So this is why it's so important for people to understand, if you have property in different states, every state has their own law. Okay? Very different. Each municipality might have different laws. All right? So before filing a suit for possession, the landlord must give a notice, depending on the state, notice to pay or quit, right? If it's something else, then it's a notice, hey, you have these amount of days. If that deadline passes without satisfaction, the landlord may file the suit and obtain judgment. And then the landlord may then obtain an order directing the sheriff to complete the eviction, which is forcing the person out if they don't leave. Okay? The most common form of landlord default, because yes, the landlord could be the reason why somebody leaves. Okay? The landlord could be the reason why somebody doesn't pay the rent. And we're going to talk about that better in New Jersey. But if the landlord defaults in maintaining the property in a habitable condition, the third time I'm mentioning this today, you have to maintain in habitable condition. If the landlord fails, then the tenant can evict himself. That's called a constructive eviction. A constructive eviction is where you're letting the landlord know, hey, you were supposed to do this or you're supposed to do that. I don't have water. I don't have heat. Whatever the condition might be. So because I don't have it, hey, I'm out. See ya. Okay? So that's what it is. You evict yourself. You get out of it. Why would you evict yourself? One, because it's dangerous to be in that property. And two, because if you don't do a constructive eviction, you will be liable, if you leave, you will be liable for the remaining terms of the contract. So let's say you have 6 months left in your contract, the leasing agreement, when you leave the property, you would have to still pay the 6 months. So constructive eviction is you letting the landlord know you did not do your part, therefore I'm relieved of the obligation to pay. You guys got it? Thumbs up? Cool. All right, we already covered all this, covered all this, covered all this. Everything with an attorney. It doesn't have to be through court, but it has to be a notice. A notice from your attorney would be ideal. Don't try to do this yourself. You can always ask Jeeves and get the wrong form, but you can ask your attorney to prepare a simple letter saying, "Hey, this is the reason why I'm leaving." That's all it is. Okay. Uniform Residential Landlord and Tenant Act. This is just a model. Again, every state has their own rules, but nationwide, they try to create a basic or standard for landlords and tenants to follow. So again, it acts to equalize and standardize the terms of landlord and tenants, protect tenants from unethical practices, prevent unfair complex leases and their enforceability, and so on. So you cannot demand too much, but you also have certain rights against the tenants and vice versa. Okay. Okay, we already talked about this, talked about that. These are the standards. I already gave you guys an overview of all this. And we're done with this chapter, 717, not bad. All right, so chapter 8, we're going to go for the quick break now, and then we're going to go into chapter 8, 717. So 7:30, we'll be back for chapter 8. Deal? You guys got right now 12 minutes. Run, get your coffee, go get Red Bull, go get whatever you need to get, go jump up and down, go to the bathroom, go eat. 12 minutes. We'll be right back.